Hello everyone, this is ARCHITA NAMBIAR and I'm here to present on the topic Grounds of Divorce Available to a Hindu Wife. So in ancient India, marriage was considered or viewed as an insoluble association of the couple, and hence this very concept of separation or divorce, it was quite unknown or uncertain to the general Hindu law. However, today in modern India, we do have the concept of divorce, and this whole procedure of divorce puts an end to the marriage, as well as it ceases or it puts an end to all the mutual obligations that a husband and a wife have towards each other. So basically, they are free to go their own way. However, there is an exception to it. That is, divorce puts an end to all the bonds between the husband and wife except the ones concerning Section 25, which deals with maintenance and alimony, and Section 26, which deals with custody, maintenance, and education of children. Now, Section 13 of this Hindu Marriage Act, it deals with the concept of divorce. Under this section, Section 13 subsection 1 deals with the grounds of divorce that are available to both husband and wife, and subsection 2 deals with the grounds of divorce that are available to the wife only. However, we need to understand here that divorce, the very concept of divorce itself is different from the concept of judicial separation. Now, the basic difference between a divorce and a judicial separation is that the judicial separation merely suspends the marital rights and obligations during the period of subsistence of the degree, but in case of divorce, all the mutual obligations and all the rights of the husband and wife, they will cease or they will come to an end, except for the ones concerning Section 25, which deals with maintenance and alimony, and Section 26, which deals with custody, maintenance, and education of children. So moving on to the grounds of divorce that is available to both husband and wife under Section 13, subsection 1 of the Hindu Marriage Act. So starting with the first ground, which is adultery. Now, the concept of adultery, it may not be considered as an offense in many countries, but as per the Hindu Marriage Act, when it comes to the matrimonial offenses, adultery is considered as one of the most important grounds for seeking divorce. Now, adultery, what does it mean? It basically means the consensual and voluntary intercourse between a married person with another person. Now, this another person may be married or unmarried. So, initially, adultery was a criminal offense under Section 497 of the IPC. But in the case law of Joseph Shine versus Union of India, the Honorable Supreme Court decriminalized adultery. But it still remains as a valid ground for divorce. Moving on to the next ground, which is cruelty. Now, this modern concept of cruelty would include not just mental cruelty, but it would also include physical cruelty. Though it's easy to determine the nature of physical cruelty, but it's quite difficult to say much about mental cruelty. Hence, the determination of cruelty will depend upon the circumstances, the facts of each case. So some instances of cruelty would include demand of dowry, impotency, false accusations of adultery, etc. So in the case law of Naveen Kohli versus Neelu Kohli, the Honorable Supreme Court held that both mental as well as physical cruelty would be a ground for divorce. And in Shobha versus Madhukar case, the Honorable Supreme Court held that the demand of dowry would also come under the ambit of cruelty. Moving on to the next ground, which is discersion. So Section 13 of the Hindu Marriage Act also provides for discersion as a ground of divorce. Now, discersion, it refers to a situation where one spouse permanently abandons the other spouse, and that too without any reasonable justification and without any consent. So in general terms, discersion basically refers to the rejection of obligations of marriage which one party owes to the other party. Now, moving on to the next ground, which is conversion. So, under Section 13 of the Hindu Marriage Act, divorce may also be obtained if the respondent converted from Hindu religion to some other religion and ceased to be a Hindu. Now, this very term, ceased to be a Hindu, would include a person who got converted himself or herself from a Hindu faith to a non-Hindu faith, such as Parsis, Islam, Christianity, or Zoroastrianism. Moving on to the next ground, which is unsound mind, which basically refers to insanity. Now, there are two requirements that needs to be fulfilled for insanity to be a ground of divorce. So the first requirement is that the respondent must have been suffering from this unsound mind or insanity, which is incurable. And the second requirement is that the mental disorder must be of such a kind and it should be of such an extent that the respondent must have been suffering continuously or intermittently from it, and the petitioner cannot reasonably be expected to live with the respondent. So in the case law, Ram Narayan Gupta versus Rameshwari Gupta, which is a Supreme Court case, it was held by the Honorable Supreme Court that if a party is suffering from a mental disorder which is of such a kind, and if the mental disorder is to such an extent that the petitioner cannot reasonably be expected to live with the respondent, divorce can be granted on such situations. Coming to the next ground, which is venereal disease. So venereal disease generally refers to a communicable form of disease. So if a spouse suffers from a communicable form of disease which can be transmitted to the other spouse, then this can be considered as a valid ground for divorce. For example, A and B got married and later A suffered from a venereal disease which is incurable, and there's also a high chance of B getting infected by that disease if she lives with A. So here B can approach the court for dissolution of marriage. One of the best example of venereal disease would be leprosy. Next ground is renunciation. So renunciation is a typical Hindu practice or a typical Hindu notion, and the Hindu Marriage Act, which we have in India, considers renunciation as a valid ground for divorce. So a person who does this, that is renunciation, is considered as civilly dead. So if a situation arises where person A decides to renunciate the world and walk on the path of God, or if he has entered a holy order, then his wife is entitled to file for a divorce. And in this concept, the party who renunciates the world is considered as civilly dead, as I said before. The next ground is presumption of death. Now, if a situation arises where a person A has been missing for the last 7 years or more and nobody, including his wife, get any news about him of being alive or dead, then A's wife is entitled to file for a divorce. However, in such cases, the burden of proof, it will lie on the person who demands a divorce. So here in this case, the burden of proof will be upon the wife. So moving on to the last part of my presentation, which deals with the grounds of divorce available to a Hindu wife under section 13 subsection 2 of the Hindu Marriage Act. So the very first ground is that if the husband has indulged in rape, bestiality and sodomy. So since the solemnization of marriage, if the husband has been guilty of rape, sodomy or bestiality, then that would be a ground for filing a divorce petition by the wife. The second ground is pre-act polygamous marriage. So this is a ground for divorce where the husband has another wife alive at the time of the solemnization of marriage with the petitioner. So if the marriage is solemnized before the Hindu Marriage Act and the husband has again married another woman in spite of the first wife being alive, then the first wife can definitely seek a divorce. The third ground is repudiation of marriage. So this provision basically provides a ground for divorce to the wife when the marriage was solemnized before she attained the age of 15 years. And she has repudiated the marriage but before the age of attaining 18 years. So such repudiation, it may be expressed, that is, it may be either in the written form or a verbal form, or it may be implied, that is, from the conduct of the wife. Like for example, if the wife has left her husband and she refused to come back after that. And the last ground would be non-resumption of cohabitation after a decree or order of maintenance. So if a wife has obtained an order of maintenance under proceedings section 125 of CRPC or a decree under section 18 of the Hindu Adoption and Maintenance Act, and cohabitation has not been resumed between the parties after 1 year or upwards, then this is definitely a valid ground for filing a divorce petition by the wife. So if there is no cohabitation for 1 year and the husband neglects the judgment of maintenance awarded to the wife by the court, then the wife can definitely go for a divorce. So that was all about the grounds of divorce available to a Hindu wife. Thank you.